Hello, everyone, and welcome to Uncivil Law. For today's case, we have an asset forfeiture case. This is United States of America versus $39,000 in currency. In this case, the TSA discovered someone in their luggage with $39,000 in currency. They seized the money. The question at issue is, does the government get to keep this money? So let's get started with this discussion. In 2018, a routine TSA administration screening indicated the presence of an organic bulk mass in the carry-on luggage. Upon examination of the luggage, TSA observed several rubber-banded bundles of mixed denomination currency totaling $39,000. In 2018, the government filed this forfeiture action. Wells filed a verified claim, which just means it was under oath. That's what it means by verified, asserting that he's the sole and absolute owner of the money, that he was in sole and exclusive possession of the money when it was unlawfully removed from his exclusive possession and control, and that he was being victimized by illegal retention of the funds. Subsequently, Wells filed an answer to the government forfeiture complaint, denying the government's allegations on the grounds that the answer could very well tend to or actually violate his Fifth Amendment rights. So he's filing a lawsuit that says, this is my money, I was under control of the money, and the government is responding with, like, what is the money? And what's it for? And he wants to invoke the Fifth Amendment right. Now, that will help him in the criminal case, but not in a civil case, because presumptions can be taken against you when you refuse to answer questions under the Fifth Amendment for civil purposes. Pursuant to the rule of federal civil procedure, supplemental rules for admiralty or maritime claims and civil forfeiture actions, the government serves special interrogatories. An interrogatory is just a fancy question for, please answer this question. To Wells seeking information testing his assertion of ownership. In response to each interrogatory, Wells stated claimant refused to answer this interrogatory as asserting his right against self-incrimination. So the government wants to know, here are some questions we want to know about, what is the source of this money? And he says, I won't answer. Okay. The government moved for summary judgment on the issue of standing, asking the district court to strike Wells' verified claim and answer, along with Wells' naked assertions of ownership, due to failure to respond to discovery requests aimed at determining the legitimacy of it. The district court granted the motion for summary judgment, finding it failed to establish standing. All right, so this makes sense in terms of procedural process, right? So what we have is a motion to dismiss contrasted with a motion for summary judgment, right? In a motion to dismiss, we look at the naked pleadings on their own face. On the naked pleadings on their own face, we have a guy who says under oath, this is my money, it's solely my money, and nothing more. Fine. But then we move into discovery. Discovery, of course, can take many different forms. Discovery can be exchange of documents, it can be depositions, or it can be interrogatories like this. So the government can send you a list of questions that have to be answered under oath. They could have asked you in person during a deposition, but they can do it in writing too. And so they want to do it in writing. They want to do it as a series of interrogatories. Okay, fine. This guy comes back and says, well, I'm not going to answer any of your questions under the Fifth Amendment. Okay, but we're in a civil case. So that means that your failure to answer can be held against you in a civil case. It can't be held against you in a criminal case, but this isn't a criminal case, right? So your failure to answer a question cannot be held against you in a criminal case. In a civil case, it can be held against you. So you can get the court to assume the opposite. So the person comes forward and says, well, look, we asked these questions, they refused to answer it. And that means that that everything can be taken in our favor, right? The worst possible answer to this question can be taken as the answer, right? Because that's the rule, right? It can be taken against you. So the worst possible answer can be assumed, all right? And now that's part of the evidence. So now we have two pieces of evidence. We have the original naked assertion, this is mine, and then we have a whole bunch of stuff where under oath, you refuse to answer any of these questions. And it's well, look at this other evidence. And so now we're on a motion for summary judgment, right? So the court is now looking at the balancing of the evidence and seeing is there enough here? And they say, well, there's enough here, so the government wins. So that's basically what happened. This court reviews a district court's decision to strike a claim for an in rem forfeiture, which just means against property. That's what in rem is, as opposed to in persona, which would be against the person. So an in rem forfeiture, action for abuse of discretion. So we look for abuse of discretion when you strike it. However, we review de novo the district court's determination of standing to contest action. Okay, so one of the issues here is, does this guy have standing? And in order to have standing, you have to have an injury that's applicable to you. So they're saying there's not even standing. He can't even bring the complaint because, he hasn't proved that he has an interest. Let's read on. On appeal, Wells argues the government must first establish it lawfully seized the defendant's property before they're required to prove more than mere assertion of ownership. Wells is wrong. Before determining whether the government lawfully seized the property, Wells must establish he has standing to challenge the seizure. Wells bears the burden of demonstrating an interest in the currency sufficient to satisfy the court of his standing, and after discovery, mere physical possession does not suffice to show standing. So mere possession alone doesn't show a sufficient interest for you to sue, because just because you possess it doesn't mean you own it, right? And so we're looking to who's actually been injured by this, and you won't tell us. So we can't assume it's you. Instead, we require some explanation or contextual information regarding the claimant's relationship to the property. A universal invocation of the Fifth Amendment during discovery forecloses any way for the claimant to sustain the burden. A blanket assertion of the Fifth Amendment privilege does not excuse a claimant's burden of establishing standing at summary judgment stage, nor can you use the invocation as a sword to make one's assertions impervious to attack, right? So you've already made statements, right? And one of the things the Fifth Amendment generally does not protect you against, in general, of course, one of the things the Fifth Amendment does not generally protect you against is cross-examination, either in a criminal trial or otherwise. So if you open the door to something by making a statement on the stand, you can't then claim the Fifth Amendment privilege as it relates to a follow-up question as part of cross-examination. You opened the door. You had the right to remain silent. You surely had the right to remain silent, but you opened the door. So now that you've opened the door, the other side is entitled to cross-examine. You can't invoke the Fifth Amendment. And so it's exactly the same logic here. You've put out an assertion, you own it. The government wants to cross-examine. In this case, they want to cross-examine by an interrogatory because we're doing discovery, and you won't answer any of their questions. So, you can't have it both ways. You can't have it both ways. You can't open the door by offering a verified complaint, which is under oath, so you can't have it both ways. You can't swear the money's yours and then also refuse to answer any questions. That's not how any of this works. Otherwise, Wells' claim of privilege could allow him to proceed with what may be false evidence, because we have no way of testing it, no way of cross-examining, while depriving the government of any means to detect the falsity. You have no ability to confront, no ability to contest, no ability to cross-examine, because the guy's going to plead the Fifth. So all we have left is the naked assertion. That's not fair to anybody. Accordingly, we find the district court properly struck the verified claim and answer due to the failure to establish standing. We don't know it's yours because you won't answer our question. Left with nothing more than a record devoid of any claim of ownership to seize currency, the district court properly found the government was entitled to summary judgment due to Wells' lack of standing. And for these reasons, we affirm. So that is the end of our coverage of United States of America versus $39,000 in change. In this case, we learned that a person had $39,000 when they went through TSA. The government found it. They argued under oath it was theirs, but then they refused to engage in any discovery. They refused to engage in cross-examination, in this case in the form of a interrogatory, by asking for the source of the money. And they opened the door, so it can't have both ways. They can't open the door and say, you can't ask me questions. That's not fair. So as a result of all this, the money is getting seized. It does not have to be returned to Wells because he did not engage in the process. And that is the end of our coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.